So in this first lesson, looking at the subject of equity and trusts for the SQE specification, I'm going to spend some time talking about the question of equity, what equity really is, and why the concept of equity is so important for our understanding of the nature of the trust. Because fundamentally, you can't really understand how trusts work without having a basic and fundamental idea about what equity is. So we're going to talk about the idea of equity in this video, we're going to talk about the history of equity in the next, and we'll think about some of the maxims of equity that have developed over the centuries of the common law. This is an introductory part of the specification. So again, just like with all of the other SQE modules, there are just some aspects, there are some elements, there are some parts of the SQE specification that merits some introductory content, and that's what this essentially involves. We're going to essentially then develop our working knowledge of the concept of equity in this lesson. That was what the purpose of this video is going to be about. And so fundamentally then, when I say that equity is one of, if not the most important concept when we think about our developing understanding of the law of trusts, the question of what equity is, of course, then is very, very prevalent and a prominent issue. Well, the concept of the trust is arguably the most important invention from equity. So the idea of the trust is equity's greatest invention fundamentally. And so it's a good way of developing our knowledge of the concept of equity as it relates to the idea of the trust. We can generally divide equity, the word, into two broad conceptualizations. We can think about it from a theoretical perspective, a theoretical approach, and then we can think about it from a more legalistic or even doctrinal approach. Now, from the perspective of the theoretical approach, the idea of equity, equity is a concept which indeed relates to ideas concerning morality and justice and fairness. Accordingly, the concept of equity was one which derives mainly out of the works of the common law, the canon law, should I say specifically, from back in the day. The word itself derives out of the Roman law tradition of equitas. Equitas, which is of course the Latin conceptualization of justice or equality or symmetry or fairness. That's the kind of thing that we roughly can translate from Latin the word equitas to mean. From a more legalistic perspective, taking a look at the application of equity to the procedure of legal systems, we can suggest that the concept of equity was a body of law which develops out of the Court of Chancery. So we can approach equity from this more theoretical approach, and the theory does of course inform the practice, as is the case in every single area of the law. And so we can think about equity from this perspective. But for our purposes, understanding equity as the body of law that developed out of the Court of Chancery is also very, very important. Now, the origins of this body of law, the origins of where this body came from, of course, derives out of the conflict that exists between the basic concept of justice and fairness with the quite rigid conceptualizations of the common law, which might apply the law correctly, but do so resulting in incorrect or unjust outcomes. Now, while it is the case that equity exists in both a civil law and common law jurisdiction and tradition, of course, equity comes from the Latin equitas, which derives from the Roman law, which is, of course, where the majority of civil law traditions come from. It is under the common law in this country, in England and Wales, that equity remained a separate and distinct jurisdiction. Until the 1870s, equity, the equity court, the Court of Chancery, was completely distinct. They were two different types of jurisdiction. There were two different types of courts, and they would often conflict with each other. We'll get to that in the next lesson when we start thinking about the historical development. But fundamentally, there were conflicts that existed between the Court of Chancery and the regular common law jurisdiction. The aim then was to have the Court of Chancery as an institution with separate jurisdiction to make attempts to overcome some of the perceived inefficiencies of the common law. Fundamentally, you've got the common law, which is a body of law which is obviously developing alongside this idea of the Court of Chancery. It is a body of law which is common to all, which is where the phrase comes from, where the idea of the common law comes from. And fundamentally, the common law can be applied in situations which might be legally rigorous and legally correct, but lead to unjust outcomes. And it's where then equity, or the Court of Chancery in this case, steps in to provide some sort of rounding off of of some of the sharp edges of the common law, if you will. A piece of extension material that you might want to bear in mind is the case of Dudley and Dudley from 1705, where they say that equity is no part of the law, but a moral virtue which qualifies, moderates, and reforms the rigour, hardness, and edge of the law, and is a universal truth. Equity, therefore, does not destroy law, nor does it create it, but it assists it. So this is one way in which we can understand and get an idea of how courts and how legal minds have understood the concept of equity in history. That they suggest that it is not necessarily part of the common law in any meaningful way. It is a way to sort of round off some of the harsh edges of the law. And so the result of that is that it does not destroy any of the law. It doesn't necessarily create law, but it in fact just assists. It helps to moderate the law. It helps to moderate and qualify the rigour, hardness, and edge of the law. And so this gives us an understanding of what the purpose of equity is, to mitigate some of the hard parts of the common law, to provide greater remedies to those victims who are victims of such hard applications. And again, this latter point is strongly links to the equitable maxim that we will get to, that equity is a shield and not a sword. The idea that we use equity in defence. We don't use principles of equity to go on the attack, to be used as a sword. It is used as a defence, as a shield. We'll get to that when we look at the maxims of equity in a future lesson. But this, of course, is an issue that we're going to have to spend some time looking at with regards to the historical development, which is what the topic of the next lesson is going to be. Where did this area of the law come from, and why is it so important to this day?